Good afternoon, everyone. This is Joe Rodriguez, the State Long-Term Care Ombudsman at the California Department of Aging. Welcome to our webinar on abuse reporting requirement changes under Assembly Bill 40. We're pleased to have with us today Ryan Cousins, a Deputy District Attorney with the Yolo County District Attorney's Office, Lisa Coleman, Executive Director of the California Long-Term Care Ombudsman Association, and all of you, of course, joining us on this webinar. The webinar is being recorded, and I'd like to start off by thanking, first of all, Erin Martinelli with the California District Attorneys Association for helping us get the word out to local law enforcement, including district attorneys, about the changes in mandated reporting. Thanks for all of your help, Erin. I'd also like to thank Lisa Coleman from the California Long-Term Care Ombudsman Association for her work in organizing the webinars and developing the mandated reporter flowchart, which we'll be going over a little bit later. We will be taking questions during the webinar. If you can type your questions into the chat box, we'll make time at the end of the webinar to get to as many questions as we can. And at this point, I'd like to turn it over to Ryan Cousins.
Good afternoon, everyone. My name is Ryan Cousins. I'm a Deputy District Attorney with Yolo County. I think I'm hearing an echo in my microphone. I'm one of the dedicated elder abuse prosecutors in our office, and I was actually very proud to be part of the analysis that Mariko Yamada was doing before she promulgated this, the Assembly Bill. She did a study and had panels where she took an input from deputy district attorneys and from ombudsmen and representatives of long-term care facilities, and it showed a lot of insight into this problem. Joseph, if you could go to the first slide. And these slides were created by Joseph, incidentally, and did a great job summarizing the changes in the law. So the first slide describes the problem. Until 2013, elder and dependent adult abuse occurring in long-term care facilities was reported to local long-term care ombudsman or the local law enforcement agency, but the confidentiality requirements prohibit ombudsman cross-reporting crimes to law enforcement without the victim's consent or a court order. Now, for those of you that are unfamiliar with the perils that face us as deputy district attorneys, one of the problems that we face with elder abuse cases and domestic violence cases are that very often the abusers of the victim are close to them, and so that creates all sorts of conflicts. Victims are reluctant to report things to law enforcement, or if they do, then they later change their mind because of family pressure and so forth. For elders in long-term care facilities, that problem is exacerbated because, of course, the elder is typically in the long-term care facility because they have reduced mobility, they have reduced ability to take care of themselves, and so they have that feeling of helplessness. And the only people that have absolute control over their lives are abusing them. So it made the problem even worse and made them even more reluctant to report things. Usually reports would have to come through family members, and so that leaving it simply the confidentiality completely in the hands of a victim obviously hamstrings law enforcement and prevents us from being able to investigate these cases. And of course, in elder abuse cases, as we do with domestic violence cases and so forth, one benefit of sort of not having the victim in the loop is when prosecution goes forward, it's not driven by the victim. The victim can face their family members or the people that are accused of abusing them and either say, or it's obvious that they are not the driving force behind the prosecution. But without the changes, then this is something that doesn't even give us an opportunity. I remember I stated at the earlier panels and was telling Joseph today that we get in our county very, very, very few reports from long-term care facilities for elder abuse. I can think of one in the past 3 years. And I believe this is the problem. I mean, there's too many people in the facilities, and it's too easy to neglect them to have that be accurate that there is no abuse going on. It is my thought that abuse is going on. Before I go on, was there any comments that you wanted to make, Joseph? Joseph?
No, Ryan, I think, yes. Yes, Ryan. No, I think you've painted the picture accurately. Ombudsmen, up until this year, were conflicted in their role as investigators of abuse and neglect because of the confidentiality requirements that are in the Older Americans Act. We cannot disclose the identity of residents to other agencies without that resident's explicit permission or consent, or the consent of that person's legal representative. And the rationale behind AB 40 was to come up with a way of addressing that confidentiality issue in the law.
Okay. If you can go to the next slide. Okay. So this data is consistent with what we talked about during the panels, that, and this would be expected, that 3/4 of victims did not consent to disclose their identities for the reasons that I just stated. Lots of laws, even Marcy's law, are designed with the best of intentions to protect victims by protecting their confidentiality, and the laws that protect these things are well intended, but they end up actually hurting investigations and hurting the victims in the long term. And I agree with the statement that local law enforcement may not have been able to investigate criminal abuse in long-term care. One moment. So that's basically the backdrop. Those are the types of issues that we described at the panels with Mariko Yamada. I know present were lobbyists from long-term care groups that disapproved, in my mind, of efforts that we were making to change the law. Everyone gripes about further reporting requirements, and of course being placed in a position of great trust, having custody and care over helpless people, I believe prompted Mariko Yamada to advocate for this change that she accomplished. So that pretty much sets the backdrop, Joseph, but I can certainly continue to chime in if you have questions.
Thank you, Ryan. I think we'll move on right now, and then if people have questions, please again enter them into the chat box, and we will have them fielded by the appropriate panelist today. Mm-hmm. So let's look at what AB 40 actually did. Well, Assembly Bill 40, which went into effect on January 1st, 2013, implements a new reporting scheme for mandated reporters to report physical abuse that occurs in long-term care facilities. The initial reporting of some types of physical abuse must be reported now directly to local law enforcement. And there are attempts to align reporting requirements here in California with requirements for skilled nursing facilities under the Elder Justice Act. Shortly before AB 40 was introduced, Congress passed and the President signed into law the Affordable Care Act, which included provisions for the Elder Justice Act. In the Elder Justice Act, if a facility, long-term care facility, receives $10,000 or more in federal funding, they are to report suspicions of crimes or actual crimes committed in the facility to local law enforcement as well as their licensing agency. As AB 40 was making its way through the legislative process, both the Centers for Medicare and Medicaid Services and the California Department of Public Health issued guidance to long-term care facilities on their reporting requirements in the Elder Justice Act. And so in part, AB 40 attempts to align state law with federal law. Abuse occurring in a long-term care facility has traditionally been the jurisdiction of either the local long-term care ombudsman program or local law enforcement. Mandated reporters had an option that if you worked in a SNF, skilled nursing facility, a residential care facility for the elderly, an adult residential facility, an intermediate care facility, an adult day program, or a congregate living health facility, mandated reporters had the option of reporting abuse to either local law enforcement or the local long-term care ombudsman program. The question now that mandated reporters will have to ask themselves when they suspect that a crime has occurred, and in particular abuse, is it physical abuse? Because if it is physical abuse, AB 40 changes the reporting requirements for mandated reporters. AB 40 added to the definition section of the Elder and Dependent Adult Civil Protection Act and defines physical abuse that results in serious bodily injury. And that term, serious bodily injury, is taken right from the Elder Justice Act. The Elder Justice Act defines serious bodily injury as an injury involving extreme physical pain, substantial risk of death, or protracted loss of impairment of function of a bodily member, organ, or of mental faculty, or requiring medical intervention, including but not limited to hospitalization, surgery, or physical rehabilitation. So if any one of those things has happened as a result of the event that took place in the facility, that needs to be reported immediately to law enforcement. If physical abuse results in serious bodily injury, the mandated reporter must report by telephone to local law enforcement immediately, but no later than within 2 hours of obtaining knowledge of the incident. They also need to report in writing using the SOC 341 form to local law enforcement, the local long-term care ombudsman program, and the appropriate licensing agency within 2 hours of obtaining knowledge that this incident has occurred. This is a change for mandated reporters. Now, in addition to making this new telephone call to local law enforcement, they now need to put in writing on the SOC 341 what actually happened and to send it to local law enforcement, local long-term care ombudsman program, and the licensing agency. If there's physical abuse that doesn't result in serious bodily injury, let's say one resident reaches out and shoves another resident, but the other resident isn't harmed, there's no fall that occurs, there's no bruising, but there was physical contact, that report still needs to be made by telephone to local law enforcement, but it's within 24 hours of obtaining knowledge of this incident, not 2 hours where there's serious bodily injury. The mandated reporter will also, again, need to report in writing on the SOC 341 form to local law enforcement, the Long-Term Care Ombudsman Program, and the licensing agency within 24 hours of obtaining knowledge. But if there's physical abuse not resulting in serious bodily injury, and if the alleged perpetrator is a resident and has a physician's diagnosis of dementia, the mandated reporter needs to report by telephone to local law enforcement or the local long-term care ombudsman program immediately or as soon as practically possible. They also need to report in writing on the SOC 341 within 24 hours to both agencies. For other types of abuse that occur in long-term care facilities that isn't physical abuse, AB 40 does not change the reporting requirements. Mandated reporters still have the option to report by telephone to local law enforcement or the local long-term care ombudsman program immediately or as soon as practicably possible. And they also need to report in writing on the SOC 341 form within 2 working days. So again, just to be clear, AB 40 only affects reporting of physical abuse. For other types of abuse, mandated reporters still have the option of reporting to local law enforcement or the ombudsman program. For physical abuse, it's a report to both local law enforcement, the local long-term care ombudsman program, and in cases where there is serious bodily injury and physical harm, the respective licensing agency that regulates that long-term care facility, either community care licensing or licensing and certification in the Department of Public Health. Excuse me. To simplify that reporting scheme, the Office of the State Long-Term Care Ombudsman, in partnership with the California Local Long-Term Care Ombudsman Association and the local ombudsman program here in Sacramento, Ombudsman Services of Northern California, developed this mandated reporter flow chart. And this slide isn't as clear as the actual flow chart itself, but let's go through it. So you're the mandated reporter at the top. If the mandated reporter observes, has knowledge of, or reasonably suspects physical abuse in a long-term care facility, this is what you're going to need to do depending on what kind of abuse you're reporting. If it's serious bodily injury, you make a phone call immediately to law enforcement. And within 2 hours, a written report on the SOC 341 to the local ombudsman, local law enforcement, and the licensing agency. Moving to that middle set of telephones and fax machines. If there's physical abuse that does not result in serious bodily injury, a phone call within 24 hours by the mandated reporter to local law enforcement. And within 24 hours as well, a written report on the SOC 341 to the local ombudsman, local law enforcement, and the licensing agency. If the abuse is caused by a resident diagnosed with dementia, who has a physician's diagnosis of dementia, and there is no serious bodily injury, the report needs to be made immediately or as soon as practically possible to the long-term care ombudsman or local law enforcement. And within 24 hours, a written report on the SOC 341 to the local ombudsman or local law enforcement. No report to the licensing agency is needed in that last scenario. This mandated reporter flowchart has been reproduced thanks to the generosity of the California Healthcare Foundation and is being distributed through local ombudsman offices throughout the state to long-term care facilities. You'll notice there are white boxes underneath the agency that you need to report to. That's for facilities to customize these forms to type in or write in the correct phone number that they need to use to call law enforcement and to fax in their reports to the local ombudsman, to local law enforcement, and to the licensing agency. So we've tried to make this as simple as possible for mandated reporters to remember who to report to and when. Other reports of known or suspected abuse that occur in facilities has not changed. If a report of abuse has occurred in a state mental hospital, those go to the Department of State Hospitals or local law enforcement. If a report of known or suspected abuse in state developmental hospitals and centers occurs, those reports should be sent to the Department of Developmental Services or local law enforcement. That has not changed. Abuse occurring outside of any of the defined facilities, again, remains unchanged. Mandated reporters can send those reports to either Adult Protective Services or local law enforcement. At this time, I'd like to turn the webinar over to Lisa Coleman from the California Long-Term Care Ombudsman Association, and Lisa's going to talk to us about cross-reporting these reports of abuse.
Thank you, Joe. Little adjustment here, technicalities. I want to thank Joe Rodriguez and the State Ombudsman Office and Ryan Cousins for his participation. We're very excited here with CalCOA to participate in this webinar. A little bit of background for our law enforcement attendees. You know, the Ombudsman program is a federally mandated program. We are a part of the Older American Act. There are 35 licensed or 35 long-term care ombudsman programs throughout the state with just under about 900 field ombudsmen. Now these field ombudsmen, while they are trained locally, I do like to point out that these are certified by the state field ombudsman. They are, I'm sorry, there's some background noise that's distracting. The training that these ombudsmen receive comes from the state, and it is mandated that the field ombudsmen are following protocol as instructed through this certification. I like to point that out because it's important that when ombudsmen are in fields, in the communities monitoring, they're following a set protocol. These are not just their opinions or their preferences, they are following a mandate. The mandate of the Ombudsman is primarily, we have three parts: to investigate, resolve, and educate. It's that third component, the education, that has us so excited today to be participating in this webinar. This is the third webinar we've had on the AB 40 Mandated Reporters Act. The first was directed towards our RCFEs. The second webinar was directed towards skilled nursing facilities, and now today, where we're focused more on what the Ombudsman's role and that cross-reporting with local law enforcement. So that leads me back to the slide, cross-reporting. The Long-Term Care Ombudsman Program and the local law enforcement must cross-report as soon as practical. This is an important next step for us, that we are cross-reporting our investigations and what we're finding as we are monitoring the facilities and following up on these complaints. So these are the different agencies that we can cross-report with. So the Ombudsman's role, working with local law enforcement to create protocols for responding to abuse that are received by both parties. So the facility where this alleged abuse occurs is going to be sending an SOC 341 to law enforcement, to the Ombudsman, and also to the licensing agency that governs that particular facility. So all three of us are going to be getting the same report, and it's going to be really important that the local Ombudsman programs reach out and meet with the local law enforcement agencies to create systems for us to communicate this information effectively, efficiently, so that we reduce duplication and we're just more effective. The State Ombudsman's Office has created a Memorandum of Understanding template, which is really very effective and helpful to spell out what the Ombudsman's role is and how we can best work with law enforcement. We have also created a transmittal cover sheet, a fax cover sheet, that can be very helpful. Those transmittals went out to all the local long-term care ombudsman programs, and they can share that with the local agencies. They are designed to be filled with local information. It basically says if the local law enforcement agency has received this complaint and they're having a choice, are they going to investigate, and if so, the name and the contact information of the officer. And if they're not going to investigate, that's good information for the local program to know as well. So the Ombudsman's role. So, as an Ombudsman, we investigate, we resolve, and we educate. So when we're looking at this, this definition of the Ombudsman's role, the investigation is the determination of the validity of the report. That's when we are doing our work to find out the facts revolving the complaint. And then resolution, the further action as necessary. As an ombudsman, I would not feel comfortable ever telling a police officer that I didn't think they should investigate something. I think that's beyond my scope of authority. But I am very comfortable in saying it is within my scope of authority to investigate and then to share my findings. And I believe that the findings, especially when we're talking about complaints that revolve around residents that have a diagnosis of dementia, that it's going to be vital that the Ombudsman share their resolution, because in most situations that resolution is going to be better care planning, maybe it's going to be staff training or retraining, or any of a myriad of other options that the Ombudsman has to work with the facility to help resolve these issues where it's really maybe not criminal in nature. Again, I don't feel comfortable telling a police officer not to investigate something, but it is our mandate to resolve at the lowest level possible, and I know the facilities are very concerned about having uniformed police officers going through their memory care facilities and the kind of drama that can be associated with that. So I think the Ombudsman is most often the best suited to resolve. This slide goes back to explaining again that how the Ombudsman's hands are tied when a resident withdraws consent. And I just want to kind of reiterate that for our law enforcement officers, that once we've lost that consent, the Ombudsman's role is tied. And so that's where we are happy to have this cross-reporting, so that in those incidences where it is appropriate to have law enforcement doing a criminal investigation, you have the information that we have, and we can keep each other up to speed. Okay, so this is again just going over the confidentiality, and that we can't disclose confidential information without the consent of the resident or their legal responsible party. And now I'm going to turn it back over to Joe, because I can see that there are a bunch of questions that people have had.
Thank you, Lisa. I wanted, before we start taking questions, I wanted to, again, highlight something that Lisa mentioned in one of the earlier slides about coordination with local law enforcement and local ombudsman programs. AB 40, the law, actually says when a local law enforcement agency receives an initial report of suspected abuse in a long-term care facility pursuant to this subparagraph, the local law enforcement agency may coordinate efforts with the local ombudsman to provide the most immediate and appropriate response warranted to investigate the mandated report. The local ombudsman and local law enforcement agencies may collaborate to develop protocols to implement this paragraph. At our fall training conference for local long-term care ombudsman program coordinators, we released a model MOU that Lisa referenced for long-term care ombudsman agencies to enter into with local law enforcement agencies, specific to receipt and investigation of these mandated reports of abuse. We also developed a cover letter that local long-term care ombudsmen could use to send to their chiefs of police and sheriffs in their communities to broach the subject of the need for collaboration and coordination on these reports of abuse. And so to our law enforcement friends who are on the webinar today, if your local long-term care ombudsman program has not yet reached out to you, don't be surprised to be getting a phone call or a letter requesting a meeting to talk about how you're going to handle these reports of abuse in your community. We also wanted to point out as well that in some of these cases where there is serious bodily injury and there is willful abuse that's occurred, it is appropriate for law enforcement to be involved because a crime has been committed. In situations where a resident who has a physician's diagnosis of dementia and is acting out in a way that is harmful or hurtful to himself or to others in the facility, but that individual doesn't have the ability to willfully intend to commit abuse, but rather is manifesting symptoms of his disease, it may be a more appropriate care plan issue that's addressed by the local ombudsman with the facility and with the family of the resident. Facilities have a responsibility to help residents with the management of behaviors as a result of their disease, and it's not necessarily a crime that's been committed. Of course, we're certainly concerned if anyone gets hurt as a result of an outburst, but it perhaps is a more appropriate time for the local ombudsman program to be involved. And so this cover sheet that Lisa mentioned will really be helpful to local long-term care ombudsman programs in determining what law enforcement's response to the report of physical abuse that they've received is going to be. It's helpful for us to know if you're going out on the case, if you're going to defer it to the local ombudsman program, if we need to do this together. we just need to know who's going to be on first so that we're providing a coordinated response and an appropriate response, and that we're not stepping on each other's toes in responding to these reports of physical abuse. One of the other things that Lisa mentioned earlier as well is the need for cross-reporting. And as a result of legislation that was passed several years ago, AB 2100 by then Assemblymember Wolk, California law now requires ombudsmen to cross-report known or suspected physical and financial abuse to district attorneys. Again, we can only do that when we have the consent of the resident or the resident's legal representative to disclose that identity of that resident and that information. But this is another opportunity for local law enforcement and the district attorneys in particular to get involved in these cases. Okay, I think at this time we'll take questions, and I'll look at the question box here and defer to perhaps one of my other colleagues on the call today to address. The first question is, have facilities been trained via this webinar? And the answer is yes. We hosted 2 webinars last week, one for mandated reporters working in residential care facilities for the elderly, and then another one for mandated reporters working in skilled nursing facilities. Both of those presentations had speakers from the respective trade associations, California Association of Health Facilities and the California Assisted Living Association. They partnered with us on these webinars, and we will continue to train facility staff as necessary. We've been working with our local programs to help them prepare for AB 40 and to remind our intake staff of the changes in the reporting law, and that they should be reminding callers who are calling in to report abuse of these changes as well, to make sure that these mandated reporters are now following the new law. There's a question, is this a PowerPoint that we can get a copy of? Yes, all registrants should have received a copy, a PDF version of the PowerPoint yesterday. If you're looking to get a copy of the actual PowerPoint itself for your own training purposes or to customize it for your local programs, please contact me here at the state office. Our email is stateomb@aging.ca.gov. You can also reply to the GoToMeeting webinar invitation to the GoToMeeting mailbox, and they will forward any requests or additional questions to me from that mailbox. Yes, and please specify if you are requesting the slides for this webinar that you reference the webinar that was held today on January 16th. Question from the audience, are there changes to Ombudsman requirements for cross-reporting? And no, there are no changes in cross-reporting requirements for the local long-term care Ombudsman program. The previous cross-reporting requirements that were in the Welfare and Institutions Code prior to AB 40 were not changed. Next question. If local programs have a MOU with law enforcement, can it give Ombudsman authority to meet law enforcement's responsibility to cross-report to licensing? No, it wouldn't, because we would still need to have the consent of the resident to cross-report to licensing. And so if we don't have that, we can't cross-report. But remember, long-term care facilities, or rather the mandated reporter in long-term care facilities, will be reporting to licensing as well. So the licensing agencies should have the same information that local law enforcement and the local long-term care ombudsman program will have. Next question. Is there any problem with email submittal of reports from law enforcement to ombudsman and licensing? Um, there is a provision in the Welfare and Institutions Code for the electronic reporting of abuse. And this was as a result of legislation that was passed in the California legislature 2 sessions ago. And it emanated from a long-term care ombudsman and adult protective services program in Southern California. Basically, the law gives counties and APS programs and local ombudsman programs the authority to establish an internet-based system of reporting. And the law actually says a telephone report or internet report of known or suspected incidents of elder or dependent adult abuse shall include, if known, the name of the person making the report, the name and age of the elder or dependent adult, the present location of the elder or dependent adult, the names, addresses of family members or any other adult responsible for the elder's or dependent adult's care, the nature and extent of the elder or dependent adult's condition, the date of the incident, and any other information, including information that led that person to suspect elder or dependent adult abuse as requested by the agency receiving the report. To my knowledge, there aren't any counties that have actually established the reporting system. I think the one county that was the sponsor of this legislation to allow this kind of reporting to occur is still working on setting up their system. With regard to email, as opposed to an internet-based reporting system, I think the law is still pretty clear in that certain reports will need to be made by phone immediately or within certain specified time frames, and then followed up by a written report. Whether that written report comes in by fax or email, I'd have to refer to the specifics in the law to answer that question right now. I will look to see if there's a distinction between email and fax. I think the language of the law, or the language that the law uses, is written report. So whether that's typed or handwritten or transmitted by fax or email, I don't think there's a distinction that's made as long as there's a written report transmitted within the specified timelines. I think mandated reporters will be okay.
Joseph,
Yes.
if I can just weigh in real quickly. Our office is actually the only office in California that has adopted a completely paperless system. We deal with everything using electronic databases, and we also get reports by email from a law enforcement standpoint. There's nothing wrong, as we see it, from receiving reports that are attached by email. I think there's a difference between filing things when you're dealing with the civil and administrative courts, where you might have to fax something or mail it, but actually sending something by email electronically would actually make things much easier from our job's perspective as far as following up on the cases and tracking them.
I would imagine, Ryan, that's correct. The law itself just specifies written reports, so I think as long as that's transmitted within the timeline by fax, by email, or hand delivered to the office, as long as the mandated reporter is meeting the timeline that's established in the law, that's fine. Okay, next question. SOC 341 is the APS form. Does this mean that the SOC 341 form will go to law enforcement and licensing agency and APS? The author of this question is correct in that the Department of Social Services, the Adult Services branch in Social Services, is the custodian of the SOC 341 form, and they are responsible for updates to that form in consultation with the Office of the State Long-Term Care Ombudsman and the licensing agencies and the Bureau of Medi-Cal Fraud and Elder Abuse. The form is used to capture reports of abuse and neglect that occur in the community, in someone's home, in hospitals, or in long-term care facilities such as SNFs and residential care facilities for the elderly. Department of Social Services and Department of Public Health has determined that it is acceptable for mandated reporters to use the SOC form, SOC 341 form, to report instances of physical abuse to the respective licensing agencies. So if you're a mandated reporter working in a long-term care facility, you would use that SOC 341 form to report to law enforcement, the ombudsman, and the licensing agency, but not Adult Protective Services. Adult Protective Services does not have jurisdiction to investigate reports of abuse and neglect that occur in long-term care facilities. The next question. There are no reporting changes for financial abuse. Is this correct? Yes, that is correct. AB 40 only changes reporting requirements for instances of physical abuse. All other abuse is reported the way mandated reporters could report it prior to AB 40. They have the option of reporting either to the local long-term care ombudsman program or to local law enforcement. The next question. Is there a need for the ombudsman to coordinate with law enforcement for consistency of reporting or coordination of actions? We believe it's important that on each case that we receive, that we know that law enforcement has also received, that there be coordination between the two agencies to at least determine which agency would have primary responsibility for investigating the complaint and going out to the facility to talk to the resident and the reporter and other witnesses. So from our perspective, we hope that there is coordination with local law enforcement. I think the law speaks to the need to coordinate efforts to provide the most immediate and appropriate response for residents. And so we would expect that kind of coordination to exist. So that's why we encourage local long-term care ombudsman programs to make contact with their chiefs of police and sheriffs to get the ball rolling on this MOU that we've developed. We think that's going to be an important tool that will facilitate communication between our two agencies. Okay, the next question. When law enforcement receives a report from a mandated reporter regarding physical abuse, is law enforcement required to respond and investigate? Do they have the option to investigate, or can they forward it to the long-term care ombudsman program for investigation? I think I might defer to Ryan on this response. Ryan, what's your take on this?
Well, I mean, technically, law enforcement, obviously part of their job description is the investigation of crimes, but as far as having a legal requirement to investigate any particular crime, like a mandate that you shall investigate such and such a case, there isn't a such thing. That's the best way that I can describe it. They would clearly be, if there were reports of elder abuse that would just simply be disregarded, then that wouldn't be acceptable, but it's not required. It's not required by law. Law enforcement is allowed discretion under a number of circumstances to either pursue or not pursue a particular case. And the same thing with the district attorney, although the same reasoning would apply. I mean, you know, a district attorney's office that wasn't following up on cases and at least making charging decisions wouldn't be doing a very satisfactory job.
Thank you, Ryan. I think I'd agree with that. And that again stresses the importance of communication between local long-term care ombudsman programs and local law enforcement. CalCOA has developed that very easy-to-use transmittal sheet to cross-report to the ombudsman program, and the sheet will indicate what law enforcement will be doing. Will they be going out on it, or are they turning it over to us for investigation? So I think, you know, again, that really points to the importance of communicating and collaborating with your local long-term care ombudsman program to determine who is really acting on this complaint. Okay, the next question. Does having very serious decubitus ulcers, i.e. to the bone, severe dehydration, and sepsis all resulting in hospitalization and ultimately resulting in loss of limb or limbs due to necessary amputation to save the life of the resident meet the requirement of physical abuse? That's a very good question.
I can answer that, actually.
Sure, go ahead.
Well, one thing that we should keep in mind is the standard that's set forth for the reporting requirement is going to be different than the standard for prosecution. The standard for prosecution under Penal Code Section 368 is causing or likely to cause great bodily injury, which is helpfully described in the case law as more than mild or moderate injury. So it's a very open-ended standard. The juries have a wide range of discretion to determine whether something is a great bodily injury or not. That's only the reporting requirement. Based on what I've seen in the trainings I've had, it would depend on whether or not the injuries that are described were caused by neglect. Based on what I've seen here, it would seem like it would meet a definition of great bodily injury. At least I would have no difficulty going forward on something like that.
Thank you, Ryan. I think from the Ombudsman perspective, certainly when we see neglectful situations like this, for our reporting system, we do have a specific complaint code that deals with gross neglect. Neglect that is so neglectful, so gross that you can, see a stage 3, stage 4 pressure ulcer that clearly is not being attended to, and that the resident is experiencing effects because of the lack of attention to this wound. I would go ahead and report that to both law enforcement and the local long-term care ombudsman program. I think it would meet the requirement of serious bodily injury. Okay, next question. Will we get a copy of the FAQs from the webinars to be addressed at the end of the webinar? Yes, I think we can do that. The recordings will be made available, posted on our website. The other two are on the websites of the other associations, but we can go through the webinars and type up the FAQs and get them out to all the participants that were on the webinars. So good suggestion, thank you. Next question. Is there a penalty for mandated reporters who fail to meet the reporting requirement of the written report in 2 hours? Are the penalties the same as WIC 15630, and how will this be enforced? There are penalties for failure to report or impeding reports, as the author of this question mentioned. Those penalties have not changed as a result of AB 40. The same penalties would apply to individuals who fail to report or who don't meet deadlines specified in the law for reporting. AB 40 does not change those provisions. In terms of who enforces those failure to reports, I think for that I would defer again to my colleague Ryan. I guess if we become aware of a failure to report, we would certainly notice the respective licensing agencies, but I think we could probably also let local law enforcement or the Bureau of Medi-Cal Fraud and Elder Abuse know about that as well, to see if there's sufficient evidence there for local law enforcement to build a case on whether or not to prosecute that individual for failure to report. Ryan, would you want to add anything to that?
Well, something can always be referred to local law enforcement for review. I mean, we receive cases all the time. People make a big deal about charging recommendations, but we sort of review everything anew when it arrives on our doorstep, so cases can always be submitted to us for review.
Okay, very good. And again, just to remind folks, the penalty that's in current law, again, not changed by AB 40, failure to report or impeding or inhibiting a report of physical abuse as defined in 15610.63 of the Welfare and Institutions Code, in violation of this section is a misdemeanor punishable by not more than 6 months in the county jail, by a fine of not more than $1,000, or by both that fine and imprisonment. If the abuse resulted in great bodily injury or death, that fine can be no more than $5,000, or both fine and imprisonment in the county jail for 6 months. Okay, next question. Have local law enforcement been made aware of these changes? Hopefully, as a result of this webinar and introductions from local long-term care ombudsman programs, law enforcement is getting the word about these changes as a result of AB 40. I know the Attorney General's office does plan on sending out a communication to all local law enforcement about the changes in mandated reporting requirements as a result of AB 40, and I believe that guidance is coming out sometime in the near future. Next question. Is a long-term care ombudsman a mandated reporter under both federal and California definitions? Ombudsmen under federal law are not considered mandated reporters, and actually the federal U.S. Administration on Aging has suggested to states who treat their ombudsmen as mandated reporters that states should endeavor to remove ombudsmen from the list of mandated reporters because of the conflict we have in federal law and not being able to disclose the identity of a resident without resident consent. California law does treat us as a care custodian, and care custodians are considered mandated reporters. If an ombudsman actually witnesses abuse occurring, the ombudsman may cross-report that or report that to law enforcement or licensing, but that's the only exception to this rule. If we are investigating a report made to us from an individual, a mandated reporter, a resident, a family member, or anyone else, we must have the resident's consent to disclose their identity and cross-report. And again, the only exception to that is if the ombudsman directly observes or witnesses the abuse occurring. Next question. Where do we refer facilities? We have found a few of them claim they are not aware of the changes in the mandated reporting law. You can refer them to the actual law itself. Assembly Bill 40 is chaptered. It's section 15, 610 and following of the Welfare and Institutions Code. You can refer them to their respective trade associations who are also involved in educating their members about the changes in the law, or you can refer them to the respective licensing agency. The California Department of Public Health released on December 19th an all-facility letter that explains the revised mandated reporting schema under the Elder Abuse and Dependent Adult Civil Protection Act. I know Community Care Licensing in the Department of Social Services, the entity that licenses residential care facilities, is also going to be sending out guidance to their licensed facilities as well. There was an audience question, what is BMFEA? Sorry about that. Sometimes we get lost in a sea of acronyms. BMFEA stands for the Bureau of Medi-Cal Fraud and Elder Abuse within the Department of Justice in the Attorney General's office. And the Bureau is an agency that we can cross-report certain types of abuse to. Audience question again. If a resident in a SNF tells me another resident with severe dementia was abused, and as an ombudsman I cannot get a release, I understand I cannot investigate. However, can I then cross-report the complaint and to what agencies? If you receive a report from another resident that another resident in the facility with severe dementia was abused, you can certainly investigate that report to determine what happened, but you might not be able to get consent from that individual who was abused to disclose their identity. As ombudsman, we have the option of trying to obtain consent from a surrogate decision maker, a legal representative for that resident if there is one. If there isn't, you can cross-report what you believe occurred to the appropriate licensing agency, redacting the name of that resident and any identifying information. That isn't always very helpful to the licensing agency, but that's pretty much the extent of what we can do at this point in time with those types of cases. You can also try, as you know, to see if other residents in the building are experiencing that same abuse from that particular caregiver or individual, and try and obtain consent from that person to report to law enforcement and to licensing. We've got about 5 minutes left, so we'll take a few more questions. This is an unfunded mandate for the Ombudsman Program. How are local Ombudsman programs able to address these issues without any state or federal funding? When the Ombudsman Program first inherited this responsibility back in 1986, it did come without any additional funding for the program. Over the years, the Ombudsman Program, as many of you know, has experienced challenges with never really having significant or adequate funding to perform all the work that needs to be done, and that was only made worse when the governor vetoed all of our general fund back in 2008. Since then, we've been able to restore some of that funding that was lost through other sources of state funding, not general fund, but other sources of state funding, most notably the state penalties account and the quality and accountability fund. Again, that does not replace the funding that we've lost. As you mentioned, we cannot use federal funds to investigate these reports of abuse because this is not one of the activities that the Older Americans Act requires of ombudsman programs. In most other states, as many of you know, reports of abuse and neglect that occur in long-term care facilities are investigated by either local law enforcement, adult protective services, or the licensing agency. Most other states do not have their ombudsman programs act in this capacity, specifically because of the problems we have with disclosure and confidentiality. And so for that reason, because this isn't really a part of our federal mandate, we can't use our federal funds to investigate reports of abuse and neglect. So we must rely on state funds and any other resources we can muster to investigate these reports of abuse and neglect. We understand that all programs are taxed by the demands that these reports place on them, and we know that our local programs are doing the best they can to leverage other resources to help them carry out these mandates. Hopefully when the economy improves or continues to improve to a point where we can talk about general fund again, there's always the option of the state refunding some of these programs, but certainly we're not there yet. Next question, and we've got about 2 minutes. Are there any provisions to report the crime to the Department of Justice, Bureau of Medi-Cal Fraud, and Elder Abuse? Again, if we go back to the slides, we can cross-report known or suspected criminal activity. Now, you know, you could argue, I think, that a violation of Penal Code 368 is a crime and is criminal activity. You could report it to the Bureau. I know the Bureau's resources are limited as well, and they may not be able to respond to every report that is cross-reported to them, but that is another option for folks. And I think we'll take one last question. The new law still leaves in place the problem of victim anonymity, correct? Yes, that is correct. Victims can be anonymous. The reporter can also claim anonymity and confidentiality. AB 40 did not change any of those provisions. Okay, I know we had some other questions here that we're not going to be able to get to today, but we will collect these and include them in the FAQ that we will generate as a result of these webinars. And, excuse me, we'll try to get those out in the next couple of weeks to all persons who registered for the webinar. I'd like to, again, to thank Ryan Cousins from Yolo County District Attorney, Lisa Coleman from CalCOA, the Long-Term Care Ombudsman Association, Aaron Martinelli with the California District Attorneys Association, California Healthcare Foundation for their support of this project, and again, all of you who are responding to these reports of abuse and neglect, whether you're an ombudsman, whether you're local law enforcement or a district attorney. Thank you for all that you do to help protect frail and vulnerable elders and persons with disabilities who live in our state's long-term care facilities. I think with this legislation now in place, we're going to be able to better protect those folks. So again, thank you for your time this afternoon and enjoy the rest of your afternoon.